Yo,
to
YouTube, Maribacho420 The Politician. Let's get into it. Like, share, subscribe, comment, watch that
must
ass.
be returned to Gavin Newsom as the governor, that the federalized troops of Donald Trump must go. Subject, of course, to an appeal likely by Monday. I'm Michael Popak. You're on the Midas Touch Network. I've got the order in my hands. I'm going to read it to you right here. Take a minute, hit the free subscribe button over on Legal AF YouTube.
I'm ready to hear it. Read it.
980,000 subscribers. We got to get to 1 million to prepare ourselves for 2026.
I'm trying to get to 1 million subscribers too.
Okay, let's get to the new order. Let me read to you from the parts that Judge Breyer found shocking. I mean, when a federal judge once again has to cite to the Federalist Papers and our founding, you know we're in trouble. But we're also in a good place by having a judge like Breyer protecting democracy. Here's the shocking part. He says on page 10 of the order granting the preliminary injunction and banning the National Guard from being taken over anymore by Donald Trump, because Donald Trump just tried to extend the federalization in October, although there's no violent problem, there's no protest problem in California stopping him from being able to execute immigration law. Here's what Judge Breyer says. He said, defendants attempt, and that's the Trump administration, attempt to circumvent the scope of Section 12406. That's the statute by which a president can take over under limited circumstances a state militia and violate federalism. Congress has delegated to the president under a unique and discrete set of circumstances that are no longer present in California. He said the attempt to circumvent the scope of the Section 12406 by characterizing the orders by Pete Hegseth as just extensions of federalization, which they argue are therefore outside the statute's reach. Indeed, at the motion hearing, Judge Breyer continues, defendants confirmed their position that after an initial federalization, the initial takeover, all extensions of the federalization orders are unreviewable by a court forever. This is shocking, says the judge. Adopting defendant's interpretation would permit a president to create a perpetual police force comprised of state troops, so long as they were first federalized lawfully. Such a scenario would validate the founders' widespread fear of a national standing army, which they believed posed an intolerable threat to individual liberty and to the sovereignty of the separate states. He actually launches into the order granting the motion for preliminary injunction. And this is a big win for Governor Gavin Newsom, once again, just on the heels of his Prop 50 win about the congressional maps. Gavin Newsom and his valiant, intrepid Attorney General Rob Bonta, who's going to be with me for an interview exclusively on Friday about this case, they get the win here, folks. Here's what Judge Breyer, senior status judge in San Francisco, had to say to start his order. Page 1. The founders designed our government to be a system of checks and balances. Defendants, Trump, make clear that the only check they want is a blank one. 6 months after they first federalized the California National Guard, defendants still retain control of approximately 300 guardsmen, despite no evidence that execution of federal law is impeded in any way, let alone significantly.
So there's no
What's more, defendants have sent California guardsmen into other states, effectively creating a national police force made up of state troops. In response, the plaintiffs, California, moved to join this context. Defendants take the position that after a valid initial federalization, all subsequent refederalizations are completely and forever unreviewable by the courts. Defendants' position is contrary to law. Accordingly, the court enjoins the federalization of California National Guard troops. And then he cites James Madison in the Federalist Papers, number 51, to talk about how the various separations and checks and balances are supposed to work. James Madison observed, to what expedient then shall we finally resort for maintaining in practice the necessary partition of power among the several departments? That's the balance of power, as laid down in the Constitution. In other words, he's positing, how do we keep the separation of the co-equal branches of government? How do we keep it? And how do we enforce it? He answers it this way. The only answer that can be given is that as all these exterior provisions are found to be inadequate, the defect must be supplied by so contriving the interior structure of the government, as that is several constituent parts may, by their mutual relations, be the means of keeping each other in their proper places. So it's the friction between the various co-equal branches, the judiciary, the legislative, and the executive, that we get our checks and balances, not the blank check.
Hey everybody, Ben Mycelis here from the Midas Touch Network. I wanted to let you know about my podcast partner, Michael Popak's new law firm. It's called the Popak Firm. Michael Popak's pursuing his dream of starting his own law firm, really based on the popular demand by all the Midas Mighty and legal AFers who were approaching Michael Popak with their cases and saying, can you help us? And at that time, Popak was not able to. So he went out on his own. He started the Popak Firm, where he is now handling catastrophic injury cases like car accident cases, trucking cases, malpractice cases, big negligence cases, wrongful death cases. So if you or someone you know have a case like this, the consultation with Popak's firm is free. Give him a call, see if you have a case. It's thepopakfirm.com, thepopakfirm.com.
Damn, we had a commercial
or you can
inside
call
of this video, YouTube.
877-POPAK-AF, P-O-P-O-K.
Without it being
so 1-877-POPOK-AF. Give Michael Popak a call, and I'm really proud of you, Popak. Thanks for all the hard work you're putting in.
Now, you might have remembered that we've talked about Senior Judge Breyer before, because he's issued orders. He already issued an order that's up on appeal that Donald Trump violated the Posse Comitatus Act by using federal armed forces on domestic soil for domestic law enforcement purposes in violation of the Posse Comitatus Act. And we're now, we've got that appeal about what are the remedies that a judge can use for having found the violation of the Posse Comitatus Act. Can an injunction be one of them? This judge also came out of the box early on and said that the nationalization of the National Guard initially by Trump was unconstitutional. Now that got reversed.
Well, he kind of did fucking force the National Guard over there.
But we're now talking about whether in October of this year, months after any protest in front of the ICE facilities happened, whether Trump can just reauthorize through Pete Hegseth, his beleaguered defense secretary. He can just reauthorize without court review because he says so. And
this fool's trying to do shit, and he's trying to do it without having the right qualifications in order to get what he wants placed. And what's that word? What's that word called? He basically wants to be putting stuff out, as in using his chess pieces, without it first getting confirmed. And when you try to get it confirmed, you got to get it under that thing, which he's saying that it doesn't meet quota, fool, basically.
the judge says no. That's a shocking display of raw power to create a standing army that would have made our founding fathers and our framers' heads spin. This will go up on appeal. First of all, Judge Breyer, knowing that the parties need to appeal this, built in an appeal process. He said, I'm going to stay my order on my own until Monday. File your motion, emergency motion, if you will, to the Ninth Circuit. A new 3-judge panel will then make a ruling about whether I'm right or I'm wrong. He also admitted, as any good jurist would do, that he's been wrong in the past. He said, my interpretation of Section 12406, which is the governing statute, that's the delegation statute between Congress to the president, to allow the president to call up the National Guard. Normally, that's a power of Congress, but there's limited circumstances. If the president
doesn't make this final, it's what he's saying. Nothing could go get in place but he's trying to send things, because his title is supposed to overthrow the House.
Has determined through court review, after court review, that he cannot execute federal law without having used regular forces, and we'll talk about regular forces in a minute, what that means. He can't do it. He needs backup. Then and only then can he cross over and grab the state militia and federalize them, and only for the period of time that's necessary.
That's a force
Donald
right
Trump
there.
sees it as an interminable period of time, an indeterminate period of time, if you will, which also sticks in the craw of constitutionalists like Judge Breyer. So
People that
regular
still
forces
have
means
their
what?
moral.
Judge Breyer interpreted that, as many judges had, meaning you try
not
to use your
just
regular security forces for ICE,
letting
your
up.
border patrol, your local law enforcement, the sheriffs, the local police. And if only then and only then, you still can't execute on your immigration policy. You can't get the people into the facility. You can't get them to court or whatever. Then you can go get the state militia. That's the requirement to cross over and violate state sovereignty under the 10th Amendment. There's another interpretation that regular forces mean the regular forces of the armed services, the Army, the Navy, the Marines, the Space Force, the Coast Guard, etc. Either way, Judge Breyer said, even if it was what I thought it was, which is local law enforcement plus security forces, or it's the armed forces, there is no showing in the record that Donald Trump called up the armed forces or properly used security forces, and failing those efforts still could not, or using those efforts still could not execute on federal law, and therefore needed the National Guard. That issue of what is regular forces before a president can go grab as backup the National Guard and cross over sovereignty.
He has to have them people out first.
That's before the United States Supreme Court right now. The judge knows it, and he cited to it. He said, we're still waiting, coming out of an Illinois-Chicago ruling of a judge similar to this one.
That's fucked up.
We're still
Where
waiting for
everything
the
is
Supreme
over
Court
there.
to give us guidance about what is regular forces.
Trying
What
to
is
say that over there
inability
is
to
the same
execute
as
under the
over
laws.
here.
So but he can't just sit around like, well, I'll just sit around and wait for the Supreme Court
Ruffle
to give me some
thinks,
rulings.
oh, I got my chess pieces over here. He's over here running like, who's gonna stop me from putting them over here? The judge did, fool. That's what he's talking about.
He's got a job to do. They got wood to chop. Trial court judges got work to do. Appellate court judges got work to do. They can't just sit around and gaze at their navel, waiting around the United States Supreme Court to get off its ass and issue a ruling. Now, if the ruling is different than what Judge Breyer just proposed, and I think he left a wide berth to make sure his opinion would still be valid, recognizing what the rulings could be. I think what he's saying is, regardless of what those rulings are, my ruling should still be intact. But we'll see. If he has to modify it because of the Supreme Court decision, he'll do it. It'll go up to the Ninth Circuit. They'll have to make decisions waiting for the Supreme Court. This may actually lead to the Supreme Court finally getting off their ass and making the ruling, and then we'll have to come back and talk about the impact of that. Rob Bonta, the Attorney General, the winner here for democracy and for America, is going to join me on Friday on Legal AF for a brand new interview about the results in this case.
Damn, my light ran out.
As they appeal
it's
in real
time.
Hour? The Trump administration will appeal
a 3 hour
by
limit
Monday
on this
to try to get a 3-judge panel of the Ninth Circuit to rule in their favor and block Judge Breyer's order while the appeal is continuing. In the meantime, you're on the Midas Touch Network. Hit the free subscribe button here. Come over to Legal AF YouTube. Do the exact same thing to get us to 1 million subscribers. Make us big, make us robust, make us muscular before 2026. We all need it. Until my next report.
You too. This is Maribacho420 The Politician. Watch that ad.